learners, welcome to another lecture on the course of Human Rights, International Humanitarian and Refugee Law. After the World Wars, it was apprehended that Southeast Asia might follow the communist ideology due to the presence and influence of USSR and China. Therefore, Europe took keen interest in the developments of the region. In 1954, in order to enhance regional cooperation in European style, an Asian version of the European model was proposed. In the same year, the Southeast Asia Collective Defense Treaty was adopted in Manila in September. These factors were some of the reasons the Southeast Asia was the first part of Asia to get involved in regional activities in general and also in regional human rights activities in particular. Let us have a look at the unique model of Association of Southeast Asian Nations or ASEAN human rights mechanism in this lecture. In 1955, Indonesia and China initiated the slogan of Spirit of Bandung in 1955 at Asia Pacific Conference at Bandung. After that, in 1959, a proposal for Southeast Asian Friendship and Economic Treaty was presented. As a consequence, in 1961, 3 states agreed to have an Association of Southeast Asia ASA to promote cultural and economic cooperation. Although ASA could not be launched, however, it is considered a step towards the establishment of the ASEAN. By the mid-1960s, the leadership in Southeast Asia began to change, which proved to be favorable for regional integration. On 8 August 1967, the foreign ministers from Indonesia, Malaysia, Singapore, the Philippines and Thailand issued the Bangkok Declaration, which was the ultimate step to create the ASEAN. With the creation of the ASEAN, Asia added a new feature to its dynamics of regionalism. Southeast Asia began to converge concretely in 1967 with the establishment of the regional organization known as the ASEAN. Initially, there were 5 members: Indonesia, Malaysia, Singapore, Thailand and the Philippines. Brunei Darussalam joined later, and in mid-1990s, the organization expanded markedly with 4 new members: Cambodia, Laos, People's Democratic Republic (PDR), Myanmar and Vietnam. Currently, the ASEAN embodies 10 Southeast Asian countries. It is important to mention the challenges faced by Southeast Asia from the 1960s till the end of the 1980s. The Indochina War was raging in Southeast Asia. Myanmar had its own problems at home with the Hamitic military-based regime and conflict with the democracy groups and ethnic minorities. It was a great achievement to bring former foes together in the 1990s as the Southeast Asia 10. A broadened ASEAN brought peace and convergence at the interstate level to the previously fractious region. A favorite phrase in the region is unity in diversity, implying a variety of cultures, religions and polities in the region under the one umbrella. The ASEAN was established principally as a political organization. It is interesting to note here that ASEAN as an organization was not meant to be an organization focused on human rights. The Bangkok Declaration of 1967 did not mention the term human rights, and the term itself was viewed with hesitation by various governments in the region. In 1976, Treaty of Amity and Cooperation (TAC), which was adopted to promote relations among ASEAN members, also did not refer to human rights. The emphasis on the establishment of a regional human rights mechanism came with the 1993 World Conference on Human Rights held in Vienna. Its declaration and program of action called for the setting up of national and regional mechanisms for human rights protection worldwide. ASEAN's foreign ministers responded by issuing a statement committing themselves to the possibility of a regional human rights mechanism. The earliest civil society group to take up this challenge was the Civil Society Working Group for an ASEAN Human Rights Mechanism, or Working Group, formed in the mid-1990s, and it targeted specifically for the purpose of human rights. As mentioned earlier in this lecture, the Vienna Declaration highlighted the need for regional arrangements for the promotion and protection of human rights and reiterated the need to consider the possibility of establishing regional and sub-regional arrangements for the promotion and protection of human rights where they do not already exist. Taking serious note of these, ASEAN in the 26th ministerial meeting in July 1993 declared in a joint communique and declared that in support of the Vienna Declaration and program of action, ASEAN should also consider the establishment of an appropriate regional mechanism on human rights. The idea of promotion of human rights within ASEAN could find roots gradually but swiftly in 1997 to mark the 30 years of establishment of ASEAN. ASEAN Vision 2020 was declared, in which the organization reiterated its commitment towards human respect and care for the community. In order to implement the plans mentioned in the ASEAN Vision 2020, in 1998, the Hanoi Plan of Action, which was for 1999 to 2004, was adopted. In this plan also, there was focus on human rights, related information to be shared by the ASEAN countries so that a commonality could be developed on this matter. Also, it was decided to work for the implementation of the UN conventions, that is, the Convention on the Rights of the Child and the Convention on the Elimination of all forms of discrimination against women. In 2003, ASEAN took yet another step towards human rights initiatives in the form of the Declaration of ASEAN Concord II, or the Bali Concord, and established an ASEAN Socio-Cultural Community ASCC. In the very next year, in 2004, the Vietnam Action Program 2004 to 2010 was adopted, wherein there was a proposal to have a commission for the protection of the rights of the migrants and a separate commission for the rights of women and children. Another important contribution of this program was that it emphasized the need for ASEAN Charter for the first time at such a platform. While ASEAN was getting closer to adopt a mechanism for human rights, it was being felt even stronger to have a charter of the ASEAN itself. Following reasons were put forth in favor of having an ASEAN Charter. Number one, an ASEAN Charter would give ASEAN a legal personality under international law and help to turn it into more of a rules-based organization. Number two, it would clarify the functions of the area of competence of key ASEAN bodies and their relationship with one another in the overall ASEAN structure as envisioned in ASEAN Vision 2020. Third, making it easier to locate who was responsible for implementing particular decisions and making it possible to hold these persons or bodies to account. Fourth, a charter would enable ASEAN to assert itself more effectively in the pursuit of its agenda and outside of the region as well. For instance, easing the legal process in the making of free trade agreements and enabling ASEAN to acquire the appropriate status for participation in international intergovernmental meetings. For the most important job of drafting a charter for ASEAN, an Eminent Persons Group (EPG) was formed which in its report in 2006 recommended that the founding principles and objectives of ASEAN be updated to include respect for human rights and fundamental freedoms. The same report was upheld at the 12th ASEAN Summit in Cebu, the Philippines in January 2007 with the Cebu Declaration on the blueprint of the ASEAN Charter, and a high-level task force was set up to begin drafting of the Charter. It was planned to present the final Charter for signature at the 13th ASEAN Summit to be held in Singapore in November 2007. The ASEAN Charter was signed by the leaders of all member states at the 13th ASEAN Summit on 20th November 2007, coinciding with the 40th anniversary of ASEAN, and entered into force on 15th December 2008 following its ratifications by all ASEAN member states. This document of ASEAN also had several human rights provisions which made it even easier to move forward with the plans of regional human rights mechanism. The ASEAN governments took up the idea explicitly in 2004 when they integrated the idea of a Women and Children's Commission in a general plan of action for the ASEAN adopted in Vietnam. It was followed by the first human rights declaration of its kind in the region, the ASEAN Declaration on the Rights of Migrant Workers in 2007. Let us have a look at the ASEAN Charter and its human rights provisions. Article 1 and Article 2 of the ASEAN Charter established the promotion and protection of human rights as a fundamental principle and underlying purpose of ASEAN, opening the way for serious human rights violations to be considered as a serious breach of the Charter. Article 14 of the Charter also committed members to the establishment of a regional human rights body. Article 14 of the ASEAN Charter just refers to an ASEAN human rights body, HuR-B, and provides for certain provisions. Like all other ASEAN organs or bodies, the HuR-B shall operate through consultation and consensus with firm respect for sovereign equality of all member states. Secondly, being an intergovernmental organization, ASEAN has only states and their governments as its members. Thirdly, the mandate of the HuR-B shall therefore include both promotion and protection of not only human rights but also fundamental freedoms. In addition to the establishment of HuR-B, the ASEAN has taken certain other steps to promote human rights in the region. For example, in 2004, Declaration on the Elimination of Violence Against Women in the ASEAN region was adopted. There is also an ASEAN Committee on the implementation of the ASEAN Declaration on the Protection and Promotion of Rights of Migrant Workers. It is working towards the development of an ASEAN instrument on the protection and promotion of rights of the migrant workers. The ASEAN Intergovernmental Commission on Human Rights, AICHR, was launched in October 2009 in accordance with Article 14 of the ASEAN Charter. AICHR's key purpose is to promote and protect human rights and fundamental freedoms of the peoples of ASEAN. In 2009, the principal human rights body, the ASEAN Intergovernmental Commission on Human Rights, was formally set up. This was paralleled by the establishment of two sectoral bodies, the ASEAN Commission on the Rights of Women and Children and the ASEAN Committee on the Rights of Migrant Workers. The ASEAN approach is very much step-by-step and non-confrontational. Moreover, like the European Union, the ASEAN itself is not a supranational organization, with the power to legislate regionally to have binding force and direct effect at the local level. Let us look into a few details of the ASEAN Commission for the Promotion and Protection of the Rights of Women and Children, ACWC. As this is a common platform for ASEAN countries, there are great opportunities for cooperation and convergent programming. The terms of reference or TOR of the ACWC were finalized in 2010. This commission is composed of 20 representatives, half specializing in women rights and half in children's rights. They are to act impartially. The term of office is 3 years, which is renewable once. This commission is due to have 2 meetings a year, and it reports annually to the ASEAN Ministers meeting on social welfare and development. While the structure of its mandate follows the TOR of the AICHR to a large extent, its functions are more focused in certain areas. In respect of its mandate and functions, there is an invitation to be proactive in Article 5, including to promote implementation of international instruments, advocate on behalf of women and children, assist in report preparation for human rights treaties and the United Nations Universal Periodic Review, encourage data collection, capacity building and review of national laws and practices, promote measures for the prevention and elimination of all forms of violence of the rights of women and children, including the protection of victims and support women's and children's participation. ASEAN Committee on the Implementation of the ASEAN Declaration on the Protection and Promotion of the Rights of Migrant Workers, ACMW, which was adopted in 2009, is also an important body. In 2007, ASEAN adopted a declaration on the rights of migrant workers, as we mentioned. This laid the foundation for an ASEAN committee on this front, and the TOR for the ACMW were finalized in 2007, followed by the establishment of this body. Although it predated the establishment of the ASEAN Intergovernmental Commission on Human Rights. AICHR and the ASEAN Commission on the Rights of Women and Children, ACWC, is an important organ of this system. Its scope is more narrow as its mandate is to help implement the declaration rather than undertake the role of promotion and protection of migrant rights in the broader sense. In terms of structure, the committee is composed of 10 persons, which is 1 per country as well as a representative from the ASEAN Secretariat. Southeast Asia National Human Rights Institution Forum, SEANF, was initially established through the signing of the Declaration of Cooperation in Bali, Indonesia on June 28, 2007, which was signed by 4 human rights institutions, namely from the countries of Indonesia, Malaysia, the Philippines and Thailand, which called as ASEAN 4 NHRIs. The forum held the 4th ASEAN consultative meeting in Manila, Philippines in 2008 and officially agreed to use the name ASEAN NHRI Forum. ASEAN 4 NHRIs became the forerunners for SEANF. It is worth bearing in mind the value added of national human rights institutions, especially when the regional system is weak or at nascent stage. They are key to the promotion and protection of human rights at the ground level and are accessible to individuals where there are complaints of human rights violations. As the regional NHRI network, SEANF plays an important role in protecting and promoting human rights in Southeast Asia. Working under a cooperative framework, SEANF members carry out joint projects or activities to discuss issues of common concern such as human trafficking, migrant workers, statelessness, business and human rights, persons with disabilities, corruptions and so on. To strengthen and to expand the networking, SEANF has been continuing to encourage the governments of each country in Southeast Asia to build independent human rights institutions. SEANF collaborates with the Asia Pacific Forum, APF, the Global Alliance of National Human Rights Institution, GANHRI, which was formerly known as the ICC, Office of the High Commissioner on Human Rights, and other human rights organizations to further promote and protect human rights at national, regional and international levels. Civil society actors and networks are also involved. The number of civil society actors such as the NGOs working on the issue of ASEAN and human rights has grown considerably through the years. While some take a low-key approach, others adopt a more assertive role. While some are linked with academic institutions, others are more grassroots oriented. While some are more local in inputs and networking, others are more from the international field. The ASEAN Human Rights Declaration or the ASEAN Declaration was adopted on 18th November 2012 in Phnom Penh, Cambodia. It is Southeast Asia's first regional instrument on human rights norms and principles. Although the ASEAN Declaration is not formally binding, it is considered the framework of human rights cooperation in ASEAN, and member states agree to follow its provisions. The ASEAN Intergovernmental Commission on Human Rights is responsible for overseeing its implementation and assisting states to achieve this goal. The ASEAN Declaration consists of 40 articles broken into categories. General principles are mentioned in articles from 1 to 9. Civil and political rights are mentioned in articles 10 to 25. Economic, social and cultural rights are mentioned in articles 26 to 34. Right to development is mentioned in articles 35 to 37. Right to peace is mentioned in article 38. Cooperation in the promotion and protection of human rights is mentioned in articles 38 to 40. AHRD is important for two reasons here. First, it clarifies the mandate of the ASEAN Intergovernmental Commission on Human Rights. Second, the AHRD is seen as a precursor to a formal treaty for the region in the same way that the American Declaration of the Rights and Duties of Man preceded the American Convention on Human Rights, and the Universal Declaration of Human Rights, the UDHR, preceded the two international covenants. The adoption of the AHRD on 18 November 2012 marked another milestone for the development of Asian human rights protection following the establishment of the AICHR. The AHRD has three distinct key features. First, emphasis rests more on the regional particularities than on the universality of human rights. Second, individuals' duties are to be weighed against human rights. And the third, the articulation of solidarity rights, of the right to a safe, clean and sustainable development, the right to development and the right to peace is also included. There are several points of concern and criticism also. For example, the drafting procedure was controversial since it was drafted by the AICHR, whose representatives are not appointed by an independent institution, but remain accountable to their appointing governments and may be replaced at the discretion of the government. Also, non-binding nature of the declaration instead of a legally binding treaty or convention may have disappointed human rights supporters. To sum up, it is very interesting to note that Southeast Asia has not failed in any way to keep a balance between unique needs of the region and have taken every relevant step to make a mark with the establishment of a culture specific mechanism for human rights. Well, that should be all for this lecture. We will meet soon with more such interesting topics. Till then, please take care and bye for now.